just by way of introductions, kind of let you know the flow and what's going to happen here today. We will start, we'll spend the first section of this meeting finishing up the fact-finding portion of this mission. So we will be hearing from banking, credit unions, and the tax commission to try to look at some of the issues that come along with how money flows in the medical marijuana industry. After that, after those presentations, after the members have had opportunity to ask questions, we'll probably take a break, I would expect, and then we are going to get back into lab testing language. Our hope and our goal is to vote at the end of this meeting. It will be the first vote that this committee has taken, and that vote will be on language that we would propose for the State Department of Health, or actually the Board of Health, in hopes that they would take our recommendations and do what they might with it, and pass some testing standards so that we are not selling untested marijuana to consumers. So that's kind of the flow for the meeting. With that, Co-Chair Echols, do you have anything before we get started? All right. Well, we will move into the presentations. Number one, and to all of the presenters, it's up to you on how you're comfortable, whether you want to stay where you are or if you want to come up and use the podium. The one thing that you do need to know is there are a pretty decent number of people in the room today, but there will be even more people who are watching this online. And so we need you to be able to speak into a microphone. That's the biggest thing. As soon as you start getting your mouth away from a microphone, my co-chair and I will begin getting text messages from people who are watching at home asking that I tell you to put your mouth next to the microphone again. So wherever, if you're comfortable sitting, if you're more comfortable standing at the podium, that's up to you. But we do very much encourage you to use the microphone so that everyone at home can hear what you're saying. With that, I will call on Mick Thompson, the Oklahoma Banking Commissioner, and the floor is yours. And I appreciate you and all of you being here today to present to us.
Well, thank you, Mr. Chairman. If it's okay with the committee, I'll just sit here and talk to you. And but if you want me to, I'll stand up at any point. So thank you for asking me to come talk about banking marijuana issues to the committee and the members. I can't really speak to State Question 788, but I can speak to the conflict between state law and federal law dealing with banking marijuana. Under federal law, marijuana remains illegal and is therefore a violation of criminal statutes for a bank or credit union to bank funds related to marijuana. But it is a business decision that the institution can make. If they choose to, but they must file Financial Crimes Enforcement Network. They must file suspicious activity reports in compliance with the Bank Secrecy Act and marijuana-related activities. I have a handout that I would ask the staff to pass out, and I'll go through this handout with you, and I brought copies of federal law that we're dealing with at the banking department. In the handout, it's information from the U.S. Department of Justice, Office of the Attorney General. And the first, and I'll go through and highlight it, and you'll have this to go through, but I'm not going to read all of it. But in the first memo that you have, it's commonly known as the Cole Amendment, which is from the Office of the Attorney General. It was issued in February 14th of 2014. And it was guidance regarding marijuana-related financial crimes. And it goes through and goes to a whole list of things that you can do to justify all what I just told you about the BSA, SARS, and everything that you have to file. The problem was when you go through all of it, it still says at the back, this memo does not alter in any way the department's authority to enforce federal law. Finally, nothing in this precludes investigation or prosecution. So they go through and tell you what you can do, and then they tell you, but it's still against federal law. The second memo we have that you have in there is from Jeff Sessions, Attorney General, that was issued on January 4th, 2018. And I'll highlight what this subject is: marijuana enforcement. In the Controlled Substance Act, Congress has generally prohibited the cultivation, distribution, or possession of marijuana. These statutes reflect Congress' determination that marijuana is a dangerous drug and that marijuana activity is a serious crime. These principles require federal prosecutors deciding which case to prosecute. Previous nationwide guidance, they're talking about the Cole Amendment I just gave you, previous nationwide guidance specific to marijuana enforcement is unnecessary and is rescinded effective immediately. So a lot of the institutions that were thinking about banking marijuana were using the Cole Amendment. The first thing that Jeff Sessions did was repeal all of that, so that is now repealed. The third thing I have in there is from bankers associations throughout the country, and this memo is signed by 16 associations, and I think it's over 20 associations now that have signed it. And it's called Cannabis Banking Coalition Position Statement. It remains illegal under federal law. The conflict being the state and federal law causes concern among both state and federal charter banks that rely on federal agencies and regulated oversight, insurance, and access to funds in the payment system. When they're talking about the payment system, they're talking about the Federal Reserve. A majority of banks will not provide depository or lending products and services to the marijuana business because of the conflict. Following the rescission of the Cole Amendment in January of 2018, it is riskier than ever for financial institutions to provide services to MRBs and to businesses that have indirect connected with the cannabis industry. U.S. Congress must pass clear legislation permitting such banking activities. Both legal matters and regulatory compliance burden must be addressed at the federal level to resolve the banking dilemma. So what we did at the banking department is that we decided that because we're going to be examining some banks that might be banking marijuana, I didn't want the bank to come back in 4 or 5 years and say, well, you checked our bank, our BSA, and you didn't even mention that we're any problems. So we're issuing a separate letter on everyone that we think that is banking any kind of marijuana, either indirectly or directly. And it basically, it says, during the review of our BSA compliance, examiners determined the bank is providing services to marijuana-related business. Bank management must remain aware that compliance with the FinCEN guidance, first thing I talked about, does not eliminate risk associated with the providing services to MRBs. Therefore, management must be made aware fully that compliance with MRBs with state law, close observance and comfort with the bank in the FinCEN guidance may not provide defense in violation of federal law. The only reason we're doing that is to be sure that we're telling them, you can do it, it's a business decision, but if you do, you're violating federal law. So we're not going to prosecute them, but we don't know that U.S. attorney might not be prosecuted. So, so the question I get then, how do we fix this? Because it is a concern in all the other states that have anything, any kind of marijuana, whether it be medical or recreational. Everybody points back to Colorado. Colorado, after 10 or 12 years of having different kinds of marijuana, has less than 10% of their financial institution that take any kind of deposits at all. Arkansas passed it in 2016. As of last Friday, no bank in Arkansas is banking any marijuana now. So the real fix is, how we fix it, is federal law. And I have spent a lot of time talking with, so there's 2 bills, and you've got copies of the front page in there. We'd be happy to get you the entire bill, or you can have your staff go online. There's 2 bills that would address some of that are in Congress. What these bills, in summary, and it's a broad section, says that if the state law whether it be recreational, whether it be medical, or whether it be nothing, whatever the state law is, the federal law would track it. So that would then allow banks to take deposits for marijuana if those bills were passed. The problem is that those bills were assigned to Judiciary Committee, and there's been a few issues going on with judges and judiciary, so they're not going to get a hearing this year. We've been working with our congressman and with several other congressmen and senators about trying to get this fix done that has to be done federally. Mr. Chairman, that's a broad overview. I'd be happy to answer questions about it, or if you want to wait until the other presenters. But we're not arguing the 788 one way or the other. What we're saying is federal law, not banking law. Federal law, it's a criminal offense to bank marijuana under current federal law.
Thank you very much. And I do want to wait until each of the presenters have gone, because I think that they're going to all come at this with different. I guess what I'm saying is I've got a list of questions that I think that the next couple of speakers may answer. So if you want to jot down your questions, and then we can ask the panel as a whole. So with that, we will move to Roger Beveridge from the Oklahoma Bankers Association. Thank you for being here, and the floor is yours.
Mr. Chairman, members of the committee, thank you very much for this opportunity to follow Commissioner Thompson and try to address some of the practicalities about dealing with the things he pointed out in his testimony. For example, the biggest obstacle for any financial institution, banks, credit unions, it doesn't really matter. You run up against the Controlled Substances Act, which criminalizes marijuana by placing it on Schedule I. And that's something that can only be changed by Congress. So nevertheless, in the last administration in 2014, commissioners already testified about the Cole memo. There was another amendment that was on an appropriations bill that dealt with funding the Department of Justice and the Department of Commerce. And essentially what it did, or does, still does, it was renewed again on September 30th, about a week or so ago. It prohibits funding for the Department of Justice to prosecute any individual or business who is operating in compliance with state law. In other words, it's illegal, but in states like Oklahoma, we're not going to give you any money to prosecute it. As a practical matter, that means you're home safe, as a practical matter, but that's how I would look at it initially. That's how I did look at it. But it opens up a number of rabbit holes as a practical matter for any financial institution that makes a business decision to finance a business that deals in marijuana. They refer to those basically as MRBs, marijuana-related businesses. The environment for financial institutions, specifically Oklahoma banks, really is one of confusion. I mentioned the Cole Memorandum. It was incorporated into the Financial Institution Crimes Network, FinCEN. It was incorporated into their guidance, not to tell you don't do it, but this is how you do it, which I thought was unique, at least in terms of trying to square the criminal risk and then the regulatory risk. Those are the two that banks and credit unions and other depositories face whenever they are asked to deal with an MRB. And then, as the commissioner testified, General Sessions rescinded the Cole memo. So you would think that would mean that it's no longer in effect. And that assumption is what I made, and I'm wrong. It is still in effect in this sense. It has not been taken out of or removed from the most recent guidance we have at the federal level from FinCEN. Even though it's been rescinded, the FinCEN guidance still says this is enforceable or something you ought to take into consideration. We were with FinCEN about 10 days ago, and they have issued no new guidance. They have no plans to do so. They blame the current administration for not giving them direction. And in other words, as of today, that guidance is still in effect. And if you think about it, the guidance incorporates 8 points, roughly, of a memorandum from the Department of Justice that's been rescinded. And if that's not a typical picture of how federal government works sometimes, I will put in with you. The Bank Secrecy Act is a huge regulatory issue for any financial institution. The idea is that they'll deputize banks and credit unions and other financial institutions to be the front line dealing with money laundering and criminal activity. No compensation for that, but it's the bank or the credit union is subjected to some very specific issues. And you'll hear people talking about SARS, which is a suspicious activity report. That applies to every financial institution. What it's based on is the bank's view of the transaction and whether that transaction might be suspicious. That's a subjective determination in every instance. But just because you're dealing with an MRB, a marijuana-related business, it is automatically considered to be a suspicious activity, regardless of whether the business is cooperating with or in compliance with state law. Other things are attached to or extend from the suspicious activity report. And because it's illegal to possess, grow, all that sort of thing, every transaction is a suspicious activity between the bank customer and the bank. You must note it. You must go into detail as to what you use to make that determination. You must keep it on file, and it's subject to being called for review by any of the federal regulatory agencies, but specifically by FinCEN. Another part of some of the acronyms that we use is we talk about AML. It stands for good, great. Say it again, please. Thank you. Yeah, I had one of those mature moments. God, I hate it when that happens. It's anti-money laundering. And it's the same kind of thing. If you think that subjectively that the MRB is engaged in some sort of money laundering activity, then you're required to document that transaction, file a SAR, and move on down the road to the CTR, the cash transaction report. And what that report does is it requires any financial institution to file information with FinCEN if the transaction is $10,000 in cash or higher. You don't have an option not to do that. And there are cases where suspicious activity is assumed because you make repeated deposits of cash that are just under $10,000. And that's an example of what FinCEN is really looking at. I could go on about the regulatory requirements. The problem is that every one opens up another rabbit hole that is potentially, will potentially get you in trouble as a banker. And so most banks in the country, I believe there are 400 and some in the country, banks and credit unions that will now bank or deal with an MRB. The criminal risk is essentially gone as long as that funding amendment is in place and as long as the FinCEN guidance remains unchanged. It's the only avenue that any bank or any credit union has to make a business decision, as the commissioner suggested, about whether to bank the business or not. And essentially, when they are confronted with that decision, a board of directors will be required to do a number of things, but not the least of which would be to make a determination about the exposure of the transaction to potential criminal charges. And it comes up, the most obvious is the bank deals with Rogers Pot Shop and opens an account for me. That's a one-to-one comparison, and that's called a tier 1 element, if you will. But that is the highest risk that you face with that customer. If you have a customer who has a loan with your bank and its collateral is a strip mall in, say, Edmond with one vacant space, and it's leased to a person that has an MRB, that's a one-to-one-to-one comparison. You got an extra step in there, and that's what they call or refer to as tier 2 exposure. Not nearly as much risk, but some. The third example is you finance, let's say, a box manufacturer who sells his or her supply to Amazon. Amazon then sells boxes to an MRB that they can use to package their product. That's a one-to-one-to-one-to-one. And that's tier 3, virtually no chance of federal prosecution. And those are things that you have to go through with every bank customer that you have, even ones that you've had for generations perhaps, but certainly for a number of years. And it's up to you, the bank, to go out and determine whether there is that exposure. And you do that through ongoing customer due diligence. So all of those things, I mean, literally, Senator, I could go on forever about these rabbit holes. It just drives me crazy. And I've been thinking about how can I get around this, you know? Because if I'm a lawyer advising the bank, I have just one word: don't. Do not do it. It is illegal. And right now, I cannot, as a lawyer, tell you how to do it, because that's unethical. And if I want to keep practicing law, then I have to consider that. I know of one bank in the state that is aggressively going after some of the business. I don't know of a lot, but I'll bet I've had over 200 calls from consumers saying, my bank says that I can't open an account here. Why not? It's legal under Oklahoma law. And I said, well, see, that's a problem, because federal law trumps Oklahoma law, and it's a crime, and they don't want to go anywhere near it. The only solution to this problem is to change marijuana from Schedule 1 to Schedule 2, or 5 preferably. That's the good news, if we could get that done. The bad news is that the Oklahoma delegation is unanimously opposed to doing anything that would make marijuana more easily accessible. And until and unless we get a larger number of states involved in the business, it's probably going to stay that way for a while. And the confusion will continue, and the public risk will continue, because it's a cash business, not credit or debit cards. As I said, I keep trying to think of ways to get around this. I'll be damned if I can. And it presents a serious problem, I think, in terms of customers, bank customers, consumers, trying to find the right path that will enable them to engage in the business of being a marijuana-related entity. I'll stop there, and I would welcome any questions that you have at any point.
Thank you very much. Up next, Nate Webb from Oklahoma Credit Union Association.
Thank you very much, Mr. Chairman, members, for this opportunity. And I, too, mostly will reiterate what's already been said from our standpoint, the credit union standpoint, because we face all of the same regulations that have already been stated. I think there's no disagreement that there is need for banking services for what now are legal entities within the state of Oklahoma for several reasons. I think it's reasonable to predict that if there are not traditional legitimate banking services available, that the money will flow somehow. And to be able to provide these services is well, a public safety issue, among other things, and also I think Mr. Maston will reiterate some of the other problems that come along with this. And so it's important for us to pursue this in a manner that is, well, I would say legitimate for us and also within federal guidelines. And has already been stated, until the federal guidelines are changed, our guidance is steer clear. And once again, as a trade association, our job is to provide the best information that we can to our members and let them make that business decision. And it's obviously an individual decision that has to be made. Much has been made already of the Cole memo, and we refer back to that again in the packet that I've handed out. It's kind of a timeline of the progression of interpretation of that memo. There have been several issued prior. But the latest, since the new administration, one of the quotes in here is telling, and it just basically says the new guidance should be viewed as increasing the legal risk to banks and credit unions that continue to provide banking service and cannabis-related business. So even though you may have considered a safe harbor available before the rescission of the memo, that safe harbor explicitly does not exist now. And it may be instructive within one of these handouts. It summarizes some of the compliance issues that even under the Cole memo were required. And it's a gauntlet of regulations that were pretty tough and pretty risky, frankly, if you were to pursue that business. So banks, credit unions, as Roger already explained, already have to comply with a variety and provide a variety of information, and there are compliance issues already in terms of suspicious activity reports, et cetera, that we all already do, but I think it's safe to predict that that work will increase dramatically, even if a bank, a credit union, other financial institutions opt not to do business. There will still be a lot of increased compliance, I think, demand on financial institutions in terms of workload, possibly additional staff, to just make sure. I mean, there is going to be an increase in business in this state, and the one-on-one that Roger mentioned, if you have a long-time member of your credit union who has a business loan, and yes, they start doing business, the strip mall is a great example, you have to monitor changes in their banking habits. Are they bringing in, more money or different kind of pattern within their banking and habits? So it's regardless, the advent of 788 will mean a change in business habits and regulatory compliance for, I think, all financial institutions. And finally, I think one of the things that we need to be cognizant of is that as a new kid on the block, if you will, with all of these, with medical marijuana now being a factor, that we could come under increased scrutiny just because we're new at this, and mistakes will be made, I think, predictably. So I think the federal government will have, at least at the beginning, some increased scrutiny on us and come under a microscope to make sure we're doing everything right, even if we ought not to take the business. It's still a factor in everything that we're going to be doing. So that kind of recaps, I think, the Commissioner and Mr. Beveridge have done a good job of kind of, summarizing everything that we'll also be dealing with. So, and again, I, too, take any questions that the committee might have. So thank you.
Thank you very much. Last but definitely not least, one of our frequent flyers in this room, Tony Maston, Oklahoma Tax Commission. Thank you for being here.
Thank you, Mr. Chairman. The Tax Commission has no statutorily imposed administrative or enforcement duties on the direct tax. That's the 7% tax on the sale of marijuana. However, we, at the request of the Health Department, we have agreed to assist them in the collection and the apportionment of the tax, and that's what we are set up to do. And so through cooperation with the Health Department and input into their rulemaking process, the Health Department rules provide for dispensaries to remit the tax to the Tax Commission and also file their report with the Tax Commission. And then with the memorandum of understanding that we have signed with the Health Department, then we are sharing that information with the Health Department and apportioning the tax dollars. As stated here, obviously it's an issue for dispensaries to pay this tax. We are set up to accept electronic payments, though we don't expect many. We are set up for the reports to be filed electronically so we can share them easily with the Health Department. And we are making arrangements and expecting large payments of cash. The statute also does not prescribe when the tax is due. However, through the Health Department rules, it is the 20th of each month. So the Tax Commission is set up in our office. We're arranging for what I call a counting machine to be placed in a room for the taxpayer to come in to make their payment of their tax into the machine. We will have, at that time, then we will have armored cars pick up the cash to take to our bank so that our employees don't have to touch or be responsible for the money or accounting for the money. We also are probably are arranging for extra security to be in our office the week of the 20th of each month to assist with the large amount of cash that we would be expect coming into our office. Counting our office over here in the Capitol grounds, we have a total of one office across the state to accept those payments. So we are looking to have just being straight up a mess on our hands. We're not set up to have 500 people walk in at 9 o'clock on the 20th of the month. So hopefully that they will scatter that out. While we don't have any licensing requirements with the Tax Commission for the marijuana tax, the dispensaries are also going to be subject to the sales tax. There is no exemption for the sale of marijuana in the sales tax code. So we expect these establishments to have a sales tax permit and also set up a payroll withholding account for any employees that they have. I do have some concerns that the last state update that I had was that there were 469 dispensary licenses have been issued, and we've only had requests for 27 sales tax permits. So we are going to have some issues there. We have, through my commission, through rules, have provided that the growers may obtain an agricultural sales tax exemption permit that's available to them. However, the processors do not qualify for a manufacturer's sales tax exemption permit. And really that's all I have, Mr. Chairman. We are setting up to be able to accept those payments and apportion the money for the health department and any other assistance that we can provide to them.
Thank you very much. Sounds like a lot of fun. Well, thank you guys, all four of you again for being here, for being willing to speak. I know it's an awkward spot, especially for the first three, in that, as Mr. Beveridge said multiple times, really want to find a way to do this, but at the same time probably cannot advise anyone to do it. And so I know it's an odd spot for the industry right now, and I appreciate you guys being willing to come and be forthright about, kind of what those struggles are and how you're trying to deal with those. So with that, we'll open up the floor to questions. Senator Yeck.
Thank you, Mr. Chairman. I appreciate all you guys being here. This topic is one I've heard about for a long time, and I've been anxious to hear what you guys had to say. Mr. Beveridge, I think you mentioned one bank that has got their doors open to this possibility. So is that right? I think you said one that you know of.
Just one that I know of, yes. And I'll stop there.
So apparently they're going against their legal counsel's advice, and they've weighed the risk and reward, and they've chosen that it's worth it to do it.
My information is that they have, and I have no idea what it is, but they have discovered a process or a practice that will enable them to handle the business. They've been examined for it in one of their out-of-state branches, and they've passed, if you will. So they feel pretty comfortable from a legal standpoint, as long as they keep up the compliance requirements based on the FinCEN guidance. I know that sounds crazy, but it's the only one I know of in this state. There are a number, I think, in other states that are doing it somehow, but I have yet to be convinced that any of those banks have discovered a way to do something without violating federal law.
Follow up.
Mr. Webb, as far as credit unions, have you heard of any of your members that are going to hang their shingle out for this opportunity?
Yeah, thank you for the question, Senator. Yes, we've heard of one credit union that has signaled their intention to go ahead and take the business. And again, as Roger said, they are falling back on or relying on some guidance that they've received and looked at some of the various things that have been done in other states, as well as advice of some counsel that has dealt with this to feel as though they can proceed safely with this and comply with the, as I said, gauntlet of regulations that are related.
Follow up.
One more follow-up. Yeah.
I'll follow up a little bit on that. There's been, since the Cole Amendment was rescinded, there's been some banks in other states that have gotten out of the business of banking marijuana because they were banking on going through the definition of what was in the Cole Amendment. Now that's been rescinded. Some of those have decided that it wasn't worth the risk. And I'll just follow up a little bit about, even though they're doing that, if you read the bottom line of the Cole Amendment, finally nothing herein precludes investigation or prosecution. So even if you follow all those rules, you're still taking a chance. Now that's a business decision if you want to take that decision, but it's still against federal law and it's a federal crime. There's nothing you can do to change that unless we get those two bills that we'd like to get passed. And I would say that from the banking department, we support 100% of getting a federal fix. You should not have a state law that's in contradict with a federal law. And I've been to D.C. many times in the last 6 months trying to get something off High Center. The problem is there's still a lot of states who don't have any marijuana, or if they do, it's very limited. And so their senators and their congressmen don't want to get involved in it. Same thing with a lot of commissioners, trying to get all the commissioners together. We've had commissioners that said in their state, their governor says, we don't have it, don't take a position on it. So it's still, until every state gets involved where they have to put some pressure on Congress, on the Senate, you're going to have this problem. So we support changes in the federal law so you don't have this issue.
I think we'd all support that. That'd make all our jobs a lot easier. Director Maston, have you checked with your bank to see if they're going to receive those deposits or not?
I'm assuming my bank will accept all my tax deposits.
That might result in a, what was it, an SAR, suspicious activity report, if they take all that cash? Yeah. Thank you, Mr. Chairman.
Senator Daniels.
Thank you, Mr. Chairman. As we look towards drafting legislative implementation to go with what the voters passed with 788, I'm going to assume right now that you have nothing in particular you would like to see in the state law related to banking services. But I just wanted to give you the opportunity to say, is there anything we should anticipate and include, or is there anything at the state level we need to have in legislation to clarify or help or do anything in the area of banking services?
Commissioner?
I don't know of any, because it's, like I said, it is pretty plain in what the federal law says.
It's the same thing. There's no way I can draft something that trumps federal law. And that's the issue. That is the problem. And all the collateral things that we do around that problem are just that, collateral. They really don't mean a whole lot in terms of criminal exposure. And the commissioner has taken the lead on that with federal banking regulators and has determined to put into the report of examination the fact that the department has advised the bank that what they're doing, if they are, is illegal. So that's in their file and will be. And that's, in my judgment, an excellent practice on the part of the department. I think they're doing everything they can to help banks understand and to help citizens, consumers understand what we're all up against. We're not opposed to marijuana at all. That isn't the issue. The issue is, how do we support the business in Oklahoma and help consumers without them violating federal law? It's really that simple. It sounds crazy, but it's that simple. And I just don't know what else we can do here that will take that risk off the table. I just don't know what it is. Believe me, I've looked. I've done my research, and I've conferred with lawyers that are a heck of a lot smarter than I am, and we've all come to the same basic conclusion. That's the problem. Yeah, I hope that makes sense.
And Senator, just so we have a consensus here, that is exactly the same thing that we've done. Our compliance attorney, as well as several others, have actually had great discussions about this. And I think the only thing would be express the sense of the Oklahoma State Legislature that the federal government ought to do something. But in terms of anything that's binding, there's just nothing that we can think of either that would have any real impact on our issue.
Representative Loring.
Thank you, Mr. Chair. Let me begin by saying I'm totally out of my realm of knowledge here.
Me too.
So the way I understand the system works is that it's because the banks are associated, or the financial institutions are associated with the Federal Reserve, that's the reason the federal laws apply to them. Is that correct, or?
Please use a microphone.
FDIC also.
Okay.
So any NCUA with the credit union, so there's, I guess the quick answer, there's no way to get around it by saying, well, I'm not going to be insured by whatever, or not going to use the Federal Reserve. Doesn't work.
So then my next question would be, why can't an institution set itself up completely independent of the Federal Reserve or the FDIC or any of these other federal organizations?
First of all, you would not have any insurance on the deposits. So that's a concern from a regulatory issue that your consumer doesn't have FDIC insurance. Number two, the Federal Reserve is not going to let you into the money system, so you can't move your money. So it would actually be a depository pawn shop, if you want.
So then that leads to the question, in my district, I have 10 American Indian tribes.
They're covered.
Sovereign, dependent entities. Can they set up institutions
No,
that could
because
do this?
we have several banks in Oklahoma that's owned by Indian tribe, and they have to give up their sovereignty to get FDIC insurance or a state charter. So they would have to become under the same laws, even though they're on the Indian. It's like Mr. Beveridge said, we've looked at every way that you could to get around it. But there's nobody, and a lot of people a lot smarter than us have looked at it. For an example, every day there's a new group that comes out about a way that we can bank marijuana. And as of yesterday, there was a group came out and said, we've got all this program to help these, for you to deposit all your money, and we'll take care of all of this. And you read through what they're doing, and it's really, they're doing a back room. They're doing all the checking and all the FinCEN and all the filing. But when you get over to their bottom line, it says, oh, there's a disclaimer, by the way, this is still against federal law and you still could be prosecuted. So it all sounds good. We've got a way that you can bank it. But when you go through the whole system, it still gets to the bottom line. It's a criminal offense to bank marijuana.
Follow up.
If I may just add to that, there are a number of third parties that have developed programs, as the commissioner said. And it's almost like the proposal du jour. You get one about every day, and they all run into the same issue. There's even armored car services that are performing that business for MRBs in states like Colorado, any of the other 9 states that authorize recreational. And the cash goes through the armored car service with an electronic credit or debit. I always, debits are on the left, but I don't remember exactly how that works, but the cash never comes through the bank. Now, you would think that that would be helpful, but that would be a way around it, because you don't ever touch the cash. If I think that, I'm wrong. It is peripherally dealing with an MRB. And believe me, I've researched it. I even asked the lawyers downtown, because I thought you could maybe do something if you had an MRB on tribal land, because they are, as you suggest, a separate entity. And to the person, the lawyers that I've talked to say that does not exclude you from the enforcement of federal law on the tribal property. And whether it does or doesn't, I'm just telling you what my lawyers told me.
So one of you, and I forget which one, I apologize about that, said that there are approximately 400 financial institutions in the country that are doing it anyway. So I take it that that's a relationship between them and their MRB customer where they're both willing to accept that risk of whatever may happen.
That Representative, I know from...
That's out of 6,000 banks, by the way. I didn't make that point earlier. Excuse me, Nate.
Well, no, I would agree that with what we stated earlier, business decisions by these institutions to attempt to and believe that they can legally run the gauntlet, if you will, of the regulations laid out in the Cole memo. But I suspect that number will dwindle or certainly won't increase anytime soon, since that memo was rescinded and the new administration has made it clear, no, regardless, there's no safe harbor.
Follow up.
But regardless whether we're talking of 1 or 400, they're still getting that money that they get from the MRB into the Federal Reserve System.
That's correct. And I believe, and correct me if I'm wrong, Commissioner Roger, but there have been instances where some of these institutions or money transmitters have opted to do this business, and they've run afoul. And the ramifications to a financial institution that does run afoul are pretty significant. The individual compliance officer can even be held personally responsible and face fines themselves. You lose, some I know have lost even some of their collateral, lost their assets just for, not intentionally perhaps, but mistakenly not complying with that guidance.
Final follow-up.
Okay. So to date, have there been any prosecutions or administrative proceedings against any of these facilities that are doing it?
Which I'm aware. Oh, yeah. Not on banks that I'm aware of, at least since 2014, because there's no money available to be used for the process of going after an individual or a business that is operating in compliance with state law. You can prosecute them, you're just not going to get, the lawyers aren't going to get paid and that sort of thing. That's kind of how Congress works once in a while. They just simply don't fund the activity that you're trying to either oppose or support. And in this case, it will expire. The guidance we have now and the resolution will expire on the 7th of December. And if that is allowed to lapse, and I don't think it will be, then even those 400 people or banks and credit unions that I mentioned earlier, my guess is they'll get out of the business like yesterday because now they can come after them.
And I'd be happy to put you back in the queue if you'd like, but Representative Roberts.
Thank you, Mr. Chair. My question's on the tax side of this, taxing at the local level, municipalities, counties, and the state sales tax collections. Can local municipalities and the counties collect the sales tax as well, and how would that work?
No, the sales tax is collected by the tax commission, not only for the state, but for all cities and counties as well. The cities and counties don't do the enforcement on their own. So when we collect the sales tax, not only will we be collecting the state rate, but the applicable city and county at the same time.
The pro tem and I invited Senator Bice to join us today, and I would like to extend her the opportunity to ask questions. So she, besides being the queen of High Point beer, deals in this side of the world in the Senate quite a bit. So happy that you're here today, and more than happy to allow you to ask questions.
Thank you, Mr. Chairman. As the newly appointed chair for Senate Finance, I'm very happy to hear that my friends in the banking and credit union community are not going to be asking for legislation that will need to be addressed. I don't think that Director Maston will have that same sentiment, however. My first question is, as it relates to banking across state lines, I'm assuming that that's not allowed because of federal law as well. So it's not as though an MRB could set up shop in Oklahoma and bank with one of the other states that's providing that services. Is that correct?
That is correct. That is a specific point in the Cole memo that was rescinded, but yet still is contained in the FinCEN guidance. If you take marijuana grown here and take it to the Cotton Bowl or whatever, that is still a crime, but it moves up on the scale of whether you're doing something beyond just operating a normal business.
I guess what I'm asking, though, is that from a banking perspective, could you have a business in Oklahoma, an MRB, but bank out of state?
Well, it depends on where you bank, but if you bank in Texas, for example, you're violating not only federal law, but I'm guessing you're going to be violating Texas law as well. So you got two shots at it. And they have the appropriations to prosecute you for violation of state law.
And I would say also that that's something that we already look at. If you have, let's say we have a member who happens to live in Colorado now and has an account here in the state, that's something that's already part of the due diligence that we're required to do already.
This question actually is for Director Maston. You mentioned that you are looking into armored vehicles, additional security, et cetera. Do you have an estimated cost for that at this time?
No, I don't. I'm sorry.
Representative Rosecrans.
Well, thank you all for coming out here. I also have been waiting. I know there's not much that can be done. I truly do understand the federal and the state deal. My question is, let's talk about the other states. There's 31, I believe, now that have either legalized medical marijuana or recreational. And my question really, since we really can't do a whole lot right now, it's just kind of a hypothetical, or at least maybe you've looked into it. What's been the best way to finance these MRBs in other states, besides putting money under a mattress, basically? Because that's basically what some people are thinking they have to do right now. I'm just trying to see, there's thriving businesses in these other states. I'm just trying to get a feel for what's been the best way, in your opinion.
The ones I've seen just charge the hell out of it, and they make a lot of money doing it, and that offsets, in their judgment, the risk of certainly criminal activity. And if they do their due diligence and follow all the regulations that the department and the FDIC and so forth require, they're going to make a heck of a lot of money.
Yeah.
There's also a large expense on their side, because if you remember when I read the first part, they're talking about they have to file with FinCEN, they have to file with BSA, they have to file the suspicious activity reports. When we do an examination, we're going to look and make sure they have filed all of those, and that's from the regulatory side. That's the burden they have of filing all of those. And if you set up, you almost have to set up a whole new department just to do that, and that's where they will have issues with the FDIC and the Fed and the state if they haven't filed all of those reports. So it's very costly from the business side, the operations side of the bank also.
And I might add, if I could, it appears, and I can't speak to the banking side, but I know from our side, a lot of the interest comes from some of the smaller institutions who see this as a great thing to add to the business portfolio, but ironically, the compliance cost and requirements really would require an expansion of staff and resources. So I think if you were to really pursue this and try to comply with some of the guidance that's out there that's interpreted as allowing this, you'd need a pretty significant institution to even do that.
Follow up?
Well, thank you for the answers, and that's eye-opening. My next question is, okay, we're getting away from the actual, selling of the marijuana. What about the ancillary businesses that are going to pop up out of this, such as, selling lighting or whatever else, what have you? Are you guys going to be able to provide funding for those types of things?
If I could speak to it first, but Roger mentioned a point earlier that we agree with. You'd have to be very careful with that even, depending on the degrees of separation. But it is keeping an eye on your long-term members or customers to even see a difference in their habits, in their banking. And it certainly say if someone came with $2,000 worth of $20 bills, that would be a suspicious activity unless that's something they've been doing for 20 years.
Some of the states that we've looked at, what they've done is the bank has put a percentage, let's say you're down to the third tier that Roger was talking about. They're saying, look, if you only get a percentage of, like you own a strip center, and you're only getting 10% of your income is from that particular entity, then they're saying, we'll go ahead and take that chance and bank you. But if you're getting 82% from the marijuana industry, they're saying, we can't bank you. So it's, each state's doing it a little different, but it's really a percentage of what income, when you get down to the third, fourth, fifth tier of, but it all is still under the criminal act.
Follow up.
Just to clarify, so, because I remember back before medical marijuana was legal here, and we were having issues with water pipes, those types of things. So even that type of thing, those type of businesses are not going to be, you can't touch those type of businesses. Is that correct? Oh, thank you. Okay.
Co-Chair Echols.
Thank you, Mr. Chairman. Just so there's no confusion, we have lots of people listening, to kind of wrap up what we've done in an hour and 15 minutes in one sentence. There are a host of federal issues. Each bank is going to have to decide for themselves. The only thing we need to do as the state legislature is don't make it worse. Have we done a pretty good job of describing what our job is as it relates to banking?
That sure works for me.
Boil it down here, too.
I could have done this quicker then. For a follow-up, I'm not going to ask you which bank because I get the feeling you don't want it to say, which is understandable. I guess I have a couple follow-ups. My first one is to Director Maston. First, I want to commend you. We had talked on the way up here. You've done a lot of work to be able to accept cash payments. I don't know that people fully appreciate how much work you've done to be able to do that. So I want to tell you thank you. It was very well thought out, the plan you described. I do want to point out, as to having those payments all being due on one day, wouldn't it make more sense, instead of saying due on the 20th, due on, say, the 20th through the 23rd, or the 20th through the 22nd? So if a business ends up having to wait all day to make their payments, that's their own fault. And then I did a little bit of math. If there really are 500 people, which I think is a low number, you could only get that done with 5 full-time people with 8 hours a day with no breaks, 5 full-time windows, and then you'd still leave, give or take, 20 people that you couldn't take their money. So is there something we can do logistically there to avoid a nightmare?
Well, when we worked with the health department in their rules, the statute provides no due date at all. So we set up for it to be a monthly payment and asked that it be paid no later than the 20th of the month. And it is for sales from the previous month. So they could come in on the 1st, but they would be late. But there's no enforcement mechanism from the tax commission to assess a penalty if it's there on the 21st.
That makes sense, and thank you, Director. That's clear. For last follow-up. So I have a question, and I think it's for Director Maston. So it has been brought to my attention a tax stamp issue as it relates to marijuana. It's Title 68, Section 450.2. So if you're not aware of this, let me know. But I'm going to ask it as open-endedly as possible. How would that work? Does that even apply in this case? Or is the tax commission going to require people to buy that tax stamp? Side note, what the heck is it? Why is it in there? But what I get questions about that, and as I read it, I have absolutely no idea what to tell people.
We will not require the tax stamps to be acquired and paid for to put on the product. The code that you're referencing, the statute references that the tax stamp is required only for illegal sales of marijuana. And since these are going to be legal sales, the tax stamp is not required.
For a final follow-up, do you sell a lot of those? People come in and say...
we do sell some of those stamps, mostly to stamp collectors. I will tell you, I did receive a letter with an order for a lot of product, and I responded that it would be over $1 billion, but I never heard back.
Thank you.
Representative Loring.
Thank you for your indulgence. For Director Maston, Representative Roberts asked a question that raised questions in my mind. He was talking about sales tax, but I always understood that the tax provided in 788 was an excise tax.
Excise tax is a general term meaning a tax that's not an income tax, it's on a transaction. The state question levied a 7% excise tax on the sale of marijuana. There is also the sales tax, which is a specific excise tax of 4.5% at the state rate on all sales of tangible personal property. Both taxes apply. So therefore, if in a city the state and local rate is 8%, $100 purchase, there would be the 7% marijuana tax plus the 8% state and local sales tax for a total of a 15% tax on that sale. So a $100 sale, then $115 would be required to be collected. Then the dispensary would report the $7 as the marijuana tax and the $8 for the state and local sales tax.
Well, I thank you. I'd never understood it that way, so I'm glad to have that cleared up.
Senator Yak.
Thank you, Mr. Chairman. Commissioner Thompson, I think you mentioned that the state delegation is opposed to any type of reform, and were those conversations since, I assume they're since 788 passed?
Repeat the question, please.
Did you mention that the state delegation at Washington, they're opposed to any type of reform, or is it the reform that's been proposed so far?
I think Roger said that,
Okay.
but I confirm with that in my conversation with them, trying to get one of these bills that I have in there. Both Senator Inhofe and Senator Langford have indicated that they did not support either one of those.
Follow up.
And they're very clear on the issues that you guys are faced with, that the legislature's faced with because of that.
I believe they are.
Chair has a question for Mr. Maston. Going back to your comment earlier, and I guess from my understanding, this entire collection fiasco that we're about to embark on is really the health department's problem that you volunteered to take from them. And so if that is true, do you have any enforcement powers? What are your enforcement powers? If someone chooses not to pay any of these taxes, what happens next?
No, we do not have any enforcement authority whatsoever. So we are simply set up as a payment mechanism for the health department to collect that tax. The state question, provided the tax is not paid, that there's a penalty associated with it. It does not talk about the authority of any agency to enforce the payment of the tax, and the normal penalties and interests that are associated are absent in my reading of the language.
Senator Bice.
Thank you. Along those same lines, do you know of any provisions that are a part of 788 that would allow for the cancellation of the license to be able to sell should you not pay those taxes?
No, I don't recall it. All I recall was a penalty associated with it. And I might add, though, to be more fully answered, the tax commission would have authority for failure to obtain a sales tax permit or for not paying the sales tax. Then we cancel the sales tax permit. And our enforcement people out in the field that be visiting these shops are only be visiting these shops for compliance with the sales tax and other tax laws that we administer.
Follow up.
Thank you. But it is your understanding that currently there is no provision that would allow for the rescission of a cannabis license because of failure to pay tax?
My recollection is there is not.
Representative Roberts.
Not quite sure if this question directs to Director Maston, but can municipalities or counties put extra fees out there on top of the sales tax? I mean, how would, if they go that route, do they collect them? Do you collect them?
The only thing that we collect for the cities and counties is their sales tax. I'm sorry, it would be beyond me if they have authority for any other type of fees to charge for these businesses.
Representative Rosecrans.
This is for Director Maston. You said your bank has no problems taking the money that comes in from these collections. What bank is that? Does it have the same issues?
Well, it's the Treasurer's Bank.
That's kind of what I thought. Sorry.
It's all right.
Question from the crowd.
Yeah, but it's the Treasurer's Bank, and we make our deposits through the Treasurer's Bank, which is Bank First.
Oh, thank you so much.
We've come to the list of hands that were in the air. Last chance. Thank you guys very much. It was very eye-opening. So I appreciate you coming. I appreciate you being frank. I know as heads of associations, some of those questions were uncomfortable for you, and I appreciate you being willing to come and being willing to answer them. With that, we will take a 10-minute break, and then we will move into testing and labeling. We are going to move forward. Each member should have a copy of a new set of recommendations, has highlights, has strike-throughs. Does everyone have a copy of that document? At least does everyone who wants a copy have one? So just kind of to set up where we are, at our last meeting, that's right, last week, 2 weeks ago, it all runs together at this point. We looked at the language. Everything that we're doing is based off of a working draft. It's actually version 1.5 from July 7th of this year of the rules passed by the Board of Health that were then later retracted. And I do want to make clear again that these are rules. This is not statutory language. And in the end, whatever we do today is only a recommendation to the Board of Health. What brought us here, kind of the history of why we're having this conversation and why hopefully we'll be holding this vote, is I think everyone on the committee, as far as I know, believes that testing and labeling is the one thing that we really have to deal with as soon as possible. And after having the Department of Health here a few weeks ago to discuss that further, they indicated in their testimony that they believe that they rolled back their packaging and labeling, or I'm sorry, their testing and labeling out of extreme caution after what had happened with their first set of rules, but they believe that they do have the authority to do this. With their belief that they have this authority, it is the belief of this committee that we would love for them to use that authority. And so these are recommendations to the Board of Health to go back and pass a new set of testing and labeling rules. In the end, the Board of Health may completely ignore the work that we do here today. They may adopt it exactly as we wanted, or most likely they will make some changes out of their great wisdom, hopefully making this even better, and that we will have testing and labeling in place before at least the first major harvest. So with that, we have what was distributed today, and I want to just kind of go over some of the changes from what you saw last week to what you see today. We made changes based on items that were discussed last week and were a consensus of the committee. And so those changes, I won't tell you exactly where they are, but we have removed the requirement that the patient's name and physician name are on the label. Those things are now struck from this language in front of you today. We removed the prohibition that a dispensary be able to sell seedlings. So in the language you have in front of you, they will be able to sell seedlings. We have added language to the lab accreditation requirements specifying provisional approval acceptable for the May 15th, 2019 deadline. We have, let me look here at my notes here. So one of the questions that we had last week is on the label, the wording was for use by qualified patients only. We've changed that for use by Oklahoma medical marijuana patients. That way it couldn't be contrived that someone who had a license in Colorado or some other state could come in and say, well, I'm qualified. So it makes it clear that this is for Oklahoma medical marijuana patients only. With that, those are the things that are in here that were consensus from last week's meeting. Hopefully we made those changes in a way that meets everyone's agreement. There are a handful of things from last week's meeting that we either wanted to do some homework on or that we were not completely unanimous on. And so those changes have not been made here. This only reflects the things that we walked out last week feeling unanimous about. With that, I will stop, and there are 3 amendments at the desk that deal with those things that were a little bit more questionable last week. But before we get into those, I'll open it up for questions just about kind of the language that is before you now, before we get into amendments, and then of course we can get into amendments as we see fit. And like I said, some are written. David, we have a process set up. If we desire more amendments, if we desire more changes, we can get those typed up, we can get those printed and distributed in this meeting. So our goal is, if at all possible, to pass language today, and so we can go through as many amendments as necessary to make that happen and to make everyone comfortable here. So with that, I will open it up to general questions, and we'll just kind of flow from there. Senator Paxton.
Thank you, Mr. Chairman. Going back to last week's discussion when Fenton Rood from the Department of Environmental Quality discussed the issue with his thought process that maybe there were laboratory testing capacity already that would be able to handle this, so we did maybe not need the May 15th implementation date. That could be moved up. I see the May 15th date is still in here. Can you tell us what the findings were of that, or maybe elaborate just a little bit on what went on this last week?
I will do my best, and David, tell me when I overstep here. We had a handful of conversations this week on that subject. Mr. Rood did get back with us. And I don't have it in front of me, so again, David may tell me I'm wrong here. His answer was that there are definitely laboratories that are interested. There are laboratories that want to work in this area. There are not laboratories with all of the machines necessary for marijuana testing in place. And so his estimate was, I believe, 4 months is what it would take, that it was not necessarily just labs that are starting from the ground up. And we got some other input from people at DEQ that this, and I'm going to have to look it up, the laboratory standard that we are requiring or that we're recommending that the Board of Health require, the 17025 standard, there are multiple labs in the state of Oklahoma that already have that accreditation. And so those labs would be able to expand their, I guess, line of service is what I'll call it, in pretty short order. Now, whether or not any of those labs, and I believe that there are 4 of them right now in the state of Oklahoma, whether or not any of those 4 currently accredited labs want to get into the marijuana space, we do not know. If they do, then it could be a very short turnaround that we have fully accredited labs in the state of Oklahoma. But all of that to say, at this point, it is still very much an unknown. The timeline could be much shorter than the 6 months that we laid out in here. It could be much, much faster than the 6 months that we have laid out in here. Follow up.
Thank you, Mr. Chairman. When I read this and I saw those dates when this was sent out, just kind of a little thought process here, and with that answer, we're not really sure when we would have the capacity to do that. When I read through it, I guess my problem with this, and I'm ready to move forward with what we have here, it's just this not testing, not labeling is concerning to me, and especially with THC levels and everything else that we've talked about in here. I think the direction that we might want to consider today is maybe just a possible recommendation to add to this would be that, you know, as soon as the health department deems that we do have the capacity to test this product, they can move that date forward. And that would be part of their rules, or part of our recommendation would be, you know, here's the date, we certainly ought to have this stuff up and running. But if, for example, on February the 1st, there's labs that came on, the capacity is there to test this product, that date could be moved forward by the health department. I'm sure, I know it's in their capacity and rules anyway, but maybe that needs to come from as a recommendation here too, is once you do get that capacity, we have no problem with you moving that date forward for the patient safety factor.
All right, I'll turn to my co-chair. This 6-month delay was his baby, so I'll let you respond.
Yeah, Senator, I think that's a great idea. Yeah, I absolutely would have no issue with, and maybe since we're recording this and we'll have it on there, they'll kind of have House and Senate agreeing that, and if nobody disagrees, we'll take your silence as acquiescence. But that, I mean, I would publicly say if we get up and running before that time, where we have the ability to do the testing, I have absolutely no problem with that. And I think the health department would be in a position, if they were to change their rules because there were enough labs that were there to require testing, they'd have my support in that. And I think it would be I think your point's well taken.
Thank
And
you.
I think maybe just a kind of technical answer, because it'd be very hard to do what we're talking about in this rulemaking process. I assume when whatever we pass here today is sent to the Department of Health, that we'll have a cover letter probably from the 2 of us, that maybe that is something that we would put in that cover letter, telling them, hey, you know, once you feel like we've got lab capacity in the state, we think that you ought to be testing everything, and just kind of indicate that through that cover letter and not actually through this document. Is that acceptable?
Yeah, I would say, you know, the word says beginning May 15th, maybe just say no later than May 15th. And on or before or something like that. Anyway, yeah, I think the cover letter just showing this committee's desire for the patient safety factor to move that up if it's possible. So I'm satisfied with that. Thank you.
Yeah, I'm good. Okay with that.
All right. Any, before we move to a different subject, are we good with indicating through a cover letter that we want product tested as quickly as possible, but we don't want the lack of accredited labs to keep people from getting the medicine they need? Is that the sense of the committee? Anything else on that subject? Senator Daniels.
Thank you, Mr. Chairman. Forewarn you that I have 8 questions, some of which might result in a proposed amendment, and I won't ask all 8 of them unless given permission to do so. But let me start. I'm looking at inconsistencies in language here that might be confusing to the Department of Health. They certainly were to me. On page 4, requirements for testing. testing requirements for usable marijuana. It says, unless processor has method that results in effective sterilization. They use the word unless. In the very next paragraph, testing requirement for concentrates and extracts, processors can't accept unsampled or untested marijuana. To me, there was an inconsistency. The one says unless they have a method, and the next one says you can't accept it. So if I'm reading that correctly, it's inconsistent, but I leave it to others to tell me I'm wrong. You're looking for water activity and moisture content, unless they have a method that results in sterilization. And the next one says the processors can accept, meaning from the growers, unsampled or untested marijuana. So do you see a conflict there?
Well,
I'm not sure I do.
And Representative Echols will have an answer too. I'll give you two answers. One is, one of these is for usable, one is for concentrates and extracts, so we're talking about two different products, so it very well could be two different testing protocols. My second answer would be that the language you're discussing is language that the Department of Health and the Board of Health created before, and so I'm going to trust that they knew what they were doing and that they're not going to get confused by their own language. I don't know if that's an acceptable answer, but those are my two thoughts. I didn't catch this at all.
Follow-up?
Follow-up, yes.
To you, just that I too don't know in drafting this if it was throwing lots of different ideas into each category and they were going to go back and finesse it. So I'm not being critical, it just jumped out at me. So, okay, there's one. So duly noted, we do have a question about it, but you're right, it may just be totally up to them.
Question two.
Which is on the same page, so we'll just do it because it's close.
I think we'll take all 8 of your questions unless I change my mind.
Sorry, sir. We established that we wanted to label for terpenes, but we don't put anything about testing for terpenes, concentrate extracts, and under cannabinoids. Were we intending to put a testing requirement for them in there since we have a labeling requirement for them?
I believe that I will direct you to page 3 under testing categories, and that is where they are directed to actually do those tests.
Page 3, testing.
Page 3, testing categories towards the top. We've added the word terpene there.
Okay.
So I guess maybe what you're saying is that we have not actually added a standard for how terpenes are going to be tested, but we are requiring that they are tested.
Okay. All right. We have 2 references to activation and 1 reference to intoxicating effects. I'm not sure that those 2 are the same thing, but under the labeling requirements and then the general labeling requirements and then the prohibitions and exceptions, the first 2 speak to activation, and the third one has language saying the intoxicating effects of the product may be delayed for up to 2 hours. Use of marijuana, medical marijuana, impairs your ability to drive a car, operate machinery. Nowhere else in the labeling did we require that language, but I wondered if that was also the same as activation. So again, it's just confusion on my part, perhaps.
I don't understand the question.
Okay.
I don't know where you are, I guess is my question, where you keep saying activation.
Well, let's separate them.
Okay.
Only under the 3rd section, general label requirements, prohibitions, and exceptions, do we have this language warning about the intoxicating effects of medical marijuana. Now, if that's the general label requirements, like every label's going to have that on it, then I guess you don't need to reiterate under medical marijuana labeling requirements or cannabinoid concentrates. But we had pregnancy in all three. So I just, again, am unclear as to, does it need to be in all three places or not? And I know I'm putting you on the spot.
All right, according to staff, the things under general label requirements would be on any label, no matter what form the product takes.
Okay. All right, then I will skip a couple of these and ask you if the warning from the FDA that marijuana's not been proved. Where is that? Which one? This product not approved by the FDA to treat, cure, or prevent any disease. Is that the same as under the general labeling requirements, CDS, Center for Disease? Well, that's not, I don't know what CDS is. Again, I may.
Controlled dangerous substance
Yes.
would be CDS.
So we had the language in two places, and then in that third place under general requirements said precautionary information of CDS. Again, maybe that's the health department saying the same things two different ways and they understand it and I don't. Okay.
That's going to be my guess.
Then that pretty much answers my question. I still have the amendment up there on the pregnancy language to make it consistent, but thank you for your time, Mr. Chairman.
All right. Senator Yeck.
Thank you, Mr. Chairman. We're approaching this like it's a bill, so I don't know how much wordsmithing we plan to do, understanding that the health department may take any or all of this. First of all, I agree with Senator Paxton. I'd like to maybe clarify what that date is. If we do add the language no later than, I would support that. Regarding labeling, the new language that we added under medical marijuana and the cannabinoid concentrates there at the end, and if product has not been lab tested, then that next warning goes on there. It seems, again, this is wordsmithing, but it seems has not been lab tested is kind of vague. I'm suggesting that we define that or just reference at that point has not been lab tested as defined on page 4 or something like that. I think that's the implication. You understand my point, Mr. Chairman?
Yes, and
I think that would just tighten that up a little bit.
Yeah.
And again, I don't know what the health department will do with this. We don't know, but as it is, if that's not changed, who's to say what that section of lab testing means? So I just think there needs to be some reference. What type of lab testing will preclude you from having to add that next warning on there? And it's the lab testing that's referred to later in the document.
okay.
So if that's an amendment, I don't know how you want to handle these.
Question on the amendment?
Senator Echols
Relatively
has a
minor
question.
points.
Or Representative Echols has a question.
So quick question on that. So if I'm looking at the right, thank you, Mr. Chairman. If I'm looking at the right section, though, this is in quotations. And again, I could be looking at the wrong section, but these are the actual words they have to put on the label. So we would, if we probably couldn't say, you know, not tested as defined in section 4. I mean, we'd have to come up with actual wording. Am I looking at the wrong section of what you're talking about?
I think, let me try to restate, if it's okay with you, Senator Yeck. Try to restate your question to make sure that I understand and everyone else. Is in this language right now, we're saying if product has not been lab tested, a warning stating, and then it gives the quote on the warning. You're saying that we should probably add, if this product has not been lab tested as per these rules. Otherwise, someone could do their own lab test at home and then say that they don't need this warning label. Is that?
Exactly.
Okay.
Thank you.
I think that I I'm inclined to agree with the need for that amendment. Others in the committee, are we okay with making this amendment? We'll ask David to wordsmith that and get it sent and printed and brought back before us. Other general observations, as I said, we do have some amendments that are already sitting, but I wanted to kind of get, if there were other things that needed to be brought up before we got to them, wanted to make sure, and that buys us some time to get the printing and everything done on these amendments. So, Representative Echols.
So thank you, Mr. Chairman. So just to close the loop on the terpenes on page 1, and to Senator Daniels' point, we don't list out the terpenes. Are we leaving that, and I'm okay with this, are we leaving that to the Department of Health and their final rules to determine which terpenes they want to test for, or do we want to list those out? I have a list that was given by Dr. Pasternak. I don't pretend to be an expert on terpenes. So whatever we do, I just want us to do it intentionally. So either we leave it as terpenes and the Department of Health is going to come up with a list that they want to test, or I've got a list from Dr. Pasternak. I would go to the will of the committee on that. I'm okay either way.
Senator Daniels.
Thank you, Mr. Chairman. My preference would be to provide the list and let the Department of Health determine which of those is reasonable. Is the list very, very long? Is it?
I can help with that. It's the list that ended up in the Unity bill, and it's only 1, 2, 3, 4, 5, 6, 7. It's only 8 terpenes. I could list them out, but I don't know that they would mean anything to any. I mean, they're technical names. The first one's alpha and beta. I'm going to mess it up. PINENE. But I've got a list of 8. You guys have heard Lawrence Pasternak before the committee. I'm telling everybody that's where I got it from. And I'm happy to list them out. I'm happy to leave it. My big deal is whatever we do, we just do it on purpose. So we keep coming back to this issue, and we decide either we list out the 8 as a suggestion, or for lack of a better word, we could put those in the letter and say these are the 8 we're considering. The committee heard from Dr. Pasternak. We feel like he knew what he was talking about. Department of Health, we'd like for you to consider these. At the end of the day, they're going to do what they want, but I just wanted to throw that out there so we knew what it is we're doing.
Because I had thought through this too, and I also feel like there's got to be some standard for a level that is reportable. And I've seen that, and it may be in the Unity bill. I know I've seen it from other states. I was happy to intentionally leave this a little bit vague to allow the Department of Health. I think we all, to varying degrees, have a little heartburn about exactly how. I mean, this is a weird process to begin with, and so my thought was, and it definitely could be something that's included in the letter, that we know that probably need more on the terpenes, but that we're going to trust their judgment on that. But that's my gut. So yes.
So thank you, Mr. Chairman. I would agree with that. I actually think that's a great way to do it. I'm okay to not get down too much into the minutia. See how I avoided saying getting in the weeds there. So, but not getting down too much into the minutia of this, as long as the committee kind of understands that would be the goal of telling them, and probably in the letter, it was our intent that you test for terpenes. We know that's a big change. We would like for you to work on, and knowing that we're going to come back in, and if we don't like what they do, we're going to change it. So as long, I am fully okay with that, and I would suggest that. I just want the committee to be aware and not just be you and I doing it unilaterally.
Right, absolutely. Absolutely. So any other thoughts on just leaving kind of the list and the threshold for terpenes up to the Board of Health to allow them to set those, either way they're going to set those how they deem appropriate, but not to give them any further directions other than to request that terpenes are part of the testing process? Is that the direction we want to go. Representative Loring.
So you're correct. Nobody's ever dealt with it like we're doing here. But I would reiterate the senator's question in regards to not listing terpenes under the standards of testing on page 4. Are we talking about adding it in there too?
And I won't speak for Representative Echols, but I believe that that's somewhat the question that he's asking here also, is we have not defined specifically what this terpene test is. The Unity bill has a list of 7 terpenes that should be tested for. I know language that I've seen, I'm going to guess it's in the Unity bill. I know it's in other states. Sets a minimum threshold so that you're not having to list terpenes that come in at, you know, 0.00000001. We don't do that. So the question is, are we okay with not doing that? And just kind of telling the Board of Health, we want terpenes, but leaving it to their jurisdiction to make their own rules here. That's the question. Go ahead, yes.
Yeah, and I understand that, but to Senator Daniels' point, on page 3, where we're telling what the testing categories are, and that a lab must be able to test for those, we do list terpenes there, the general category. But then on page 4, for the standards of testing, where we tell what the lab must test for, we list the THC, THCA, CBD, and on, but don't list the terpenes there.
Representative Echols.
Thank you. Representative, I think you're right. I think you could fix that by just adding, I think you and the senator was right. It just, I guess, took me a while to get it through, just for it to click. But I think I agree with both of you. Do you think, Senator and Representative, looking at page 4, we could solve that with a pretty easy amendment? So in between CBG, and it says and CBN, strike that and, put comma, and other terpenes? Yes. But understanding that we're going to leave that list up to the Department of Health as to what those terpenes are. I totally agree, and I think that makes sense, because you're dealing with one says what the lab can. Again, you said that before, and it just took, you had to explain it apparently very simply for me, but I get it now.
Senator Daniels.
Thank you, Mr. Chairman. I appreciate Representative Loring interpreting my mishmash and making it clear. But we would also then do that under cannabinoids, right? Just put that language in both those places?
I think it's in, let me make sure, again, it took me a while, Mr. Chairman, if that's okay.
Go for it, please.
I think it's in, and let me make sure I'm following. It's in on the first page under cannabinoid concentrates. We need to add it on page 4 under standards of testing. I'm going to have another change I'll talk about later to this that won't matter. And I think we can add it by striking the word and in between CBG and CBN, putting a comma, and then saying and other terpenes. Is there anywhere else you think it needs to go, Senator?
Well, just those 2 sections, the concentrates and extracts, and then under the standards for testing, cannabinoids, if I'm saying that wrong, cannabinoids on 4. So there were 2 places I was going to add terpenes.
Yeah, you're right. And so it would be THC and CB concentration, comma, and other terpenes. I think you're correct, Senator, because we're doing, yeah, I think Senator, would you mind, Representative, if I submit that to David for a part of an amendment?
Follow up?
Are you following this, Chairman? All right, so I have the same question David does, so I'll ask. Tell me specifically the 2 places that you want this amendment.
assuming it's appropriate, on page 4, I would add it to the paragraph subtitle, Testing Requirements for Concentrates and Extracts.
I got it.
And then under standards for testing, add it to the section on cannabinoids, because then that mirrors the labeling requirements we had.
Okay.
And I agree that the list of what they test for ought to go in your cover letter, not in this document.
Okay. So just to restate, we would be adding terpenes to, under requirements for testing, into the section testing requirements for concentrates and extracts, and under standards for testing into the paragraph on cannabinoids. Okay. They're working on preparing that language for an amendment. Any other things that we need to discuss? Representative Echols.
I had one that I'm having prepped right now for an amendment. It's under standards for testing. We have the section, the last full sentence, third line up, begin parentheses. It says fail when potency of THC or CBD excludes plus or minus 15% of labeled potency. I would submit we need to take out the CBD plus or minus 15% as a reason for failure. I understand the THC. We want to know what the THC content is. If somebody thinks they're getting a THC content, that needs to be relatively consistent. I don't understand why we would use as a reason for failure CBD. I mean, it doesn't make a lot of, to me, that one doesn't make, and it's interesting that they chose CBD as opposed to say THCA or CBDA or CBG or CBN. It just makes more sense. So I would submit we need to keep that for THC, take it out for CBD. And I'll yield the questions on that amendment and why. Senator Yak has a question.
Oh, Senator Yak, thank you.
Thank you, Mr. Chairman. So I'm curious why they would put that in there like that. Have you asked them that question? That seems fairly obvious, really.
Yeah, so I'm just guessing here, but it's probably a lack of understanding, if I was guessing. I can't imagine why you would be super concerned. I mean, ironically, you have a better argument for THCA plus or minus 15% than CBD, because in theory, THCA can be manipulated to get rid of the A. And I think it's because CBD is in the news, and that's the one that everybody knows what it is. So, and again, I'm just guessing, but when you look at, I mean, right now in Oklahoma, we've sold with no adverse consequences, completely untested pure CBD for 4 years. Now I'm working with that industry, and I think we probably ought to start testing, but we ought to start testing so people know what they're getting, not that there's any danger of becoming intoxicated from really potent CBD. Knowing that area, it's hard for me to understand why it would even be a concern. And even the bigger concern is you could see a low CBD content that could easily have a variation. So let's say you have a CBD product that has a very low CBD content. You could easily see a variation of plus or minus 15%, and this testing would require destruction of the entire amount, which to me seems a bit extreme when there's no real reason to do it.
For follow-up.
Follow-up, yes.
For the health, it just seems to me, for the health department to specifically put CBD in there, I just infer from that they have a health concern with that. And I'd be curious to know if that's just an oversight or why they did put that in there specifically. And I don't know how we can find that out. Maybe with your amendment, if it goes through, they realize there's a change there, they may or may not go along with it. But I'd be curious if they have health concerns with CBD being in there at that level, that 15 plus or minus. That's my curiosity, why they would specify that. I think it's important enough that it need to be in there specifically like it is.
And for a follow-up, Yeah, so for the health department that's listening, that they would be met with a relatively angry majority floor leader if they were to come in and say they have an issue with that, considering we have been selling this untested in the state of Oklahoma for the past 4 years, and I put my cell phone number on everything in the planet, and they've never once called me. So I would definitely feel like they were laying behind the log if they had an issue with the testing levels of CBDs, because they have not been they haven't been unhelpful, but nobody's come to me, and I've been talking about testing it for a while. So I hope they have a really good reason. I think my reason's probably that it's just been in the news, and the Department of Health's not experts in marijuana, but I'm sure they're listening, and if they have an issue with the testing levels of CBD, I hope they come tell me and let me know why they haven't talked to me in 4 years. That's not the Senator, your point's correct. I mean, just for me, this issue is kind of personal, so it'd be a hard pill to swallow from the health department perspective. Anyway.
All right, so this amendment actually is before you. This is one that we had typed up before the meeting had started, so it should have been distributed to you now. Any other questions, discussions? We're looking at amendment number 3 by Representative Echols. Questions, comments, thoughts? We will need to vote on this to make a change. Representative Loring.
So I would just point out, if I'm at the right place in the paperwork, that it still does not include and other terpenes.
That will come in another amendment that's being sent to the printer as we speak. Representative Yack.
Thank you, Mr. Chairman. So Senator Paxton's concerned about maybe instead of beginning May 15th, no later than May 15th, would that be a separate amendment?
Yes. But I thought that we were going to just cover that in the cover letter. Are we proposing an amendment to actually change all instances of beginning with to ending on?
Oh, yeah, never mind.
May 15th? Senator Paxton.
I think it was just the cover letter was satisfactory.
Okay.
Just to put that in the cover letter, that they can add that in there.
Okay. Senator Yack, is that okay with you? Okay. All right. Anything else on amendment number 3, which strikes the words or CBD from the cannabinoid section? If there is no other discussion, I will call for a vote on this amendment. The way we will vote is just by a show of hands so that we can record the number of votes for and against, and we don't, with 8 people voting, yays or nays would get pretty easy for me to fudge if I wanted to, so I would rather have an actual number. So all in favor of amendment number 3, signify by raising your hand. All opposed? You cannot raise your hand twice, so amendment number 3 will pass unanimously. All right. Senator Paxton.
Just protocol here. We don't need a motion or anything like that. We can just do the vote.
Well, we can do that.
I'm not worried about it if you're not.
We're still kind of making it up.
Okay. Representative Echols makes a motion. Senator Paxton, would you like to second it?
Yeah.
All in favor, raise your hands.
I feel like I'm on a board that's fixing the minutes.
Yeah, really. All right, that passes amendment number 3. I better write down Echols. Okay. If we can, will you distribute? Here, I'll distribute the first 2.
Okay.
All right, we are now distributing what will be known as Amendment number 4, which is authored by Senator Yeck. You'll see your amendment in just a moment. All right, so the change on here is 2 sections, and it is what we've earlier discussed. If product has not been lab tested, and this is what we have added, is the words, in accordance with these rules, a warning stating this product has not been tested and cannot be verified to be safe for use. So we are adding just to specify it, it has to be tested according to the rules to this. Senator Yeck, you have, I guess I just introduced your amendment, I'm sorry.
Thank you for explaining my amendment.
Yes, do you have further explanation of your amendment?
Move to accept.
We have a motion from Senator Echols, second from, I'm sorry, Representative Echols, a second from Representative Roberts. Further discussion? Seeing none, all in favor, raise your hand. All opposed, that is unanimous. Okay. We will now distribute, and if you want to go ahead and just distribute all of them that we have. So you'll be getting number 5, and then after that you'll be getting, I guess we've done 3 and 4, so you'll get to see 1 and 2. Amendment number 5 by Representative Echols. Representative Echols, would you like to explain your amendment?
This is the amendment suggested by Representative Loring and Senator Daniels. I just added in the word "and terpenes." Yield for question, move adoption.
Due pass was by who? Representative Roberts. Second, Senator Daniels. Questions? All in favor, raise your hand. All opposed, Senator Paxton, would you like to vote? Senator Paxton votes aye, and it passes unanimous. All right, we should be distributing number 1 and number 2. We will take up number 1 first. Number 1 is by me. And this is one of the questions from last week that we asked and decided we need to do a little more homework on. What we have right now in the language before you is, so this is in the section prohibited products. So anything listed here are things that a dispensary cannot sell. We have already changed to allow the sale of seedlings. My amendment is to also allow the sale of mature plants. And this was a debate last week. I'll tell you, I actually received a lot of different answers to why you would want to sell mature plants. The one that made the most sense to my little mind is basically this will allow people who want to process or patients who want to process their own marijuana but do not necessarily want to grow it. It would be somewhat the difference of you can go to the store and buy chocolate chip cookies, or you can go to the store and buy the ingredients for chocolate chip cookies. This allows someone to to purchase the raw ingredient instead of purchasing something that has already been processed. So with that, I think there probably is a need or a reason that someone might want to purchase a mature plant. Obviously, these would be people who have to have a license to own a mature plant, so I don't see why we would prohibit it, which is, I believe, what Representative Echols said all along. It just took me a week to figure out that he was right.
I'm wrong a lot, too.
Well, that's why it took me a week. I fact check most everything you say.
That's right. As well you should. Do pass.
Representative Echols with due pass, I will second. Senator Daniels at least has a face that looks like it wants to ask a question.
Yes, my face does. Thank you, Mr. Chairman. Just confirming from my own understanding, of course, the limits on how many mature plants you can possess would apply here. So you're not, okay, you don't need anything about limiting numbers because that's already stated elsewhere.
That's my belief, yes. Other questions on amendment number 1? Seeing none, we have a due pass. We have a second. All in favor, raise your hand. We have 8 in favor, opposed. Can't have any, so that passes unanimous. All right, we have amendment number 2 by Senator Daniels. Senator Daniels, would you like to explain your amendment?
Thank you, Mr. Chairman. On page 1 and 2, we have 3 different references to a warning about use of medical marijuana during pregnancy. 2 of them read, marijuana use during pregnancy or breastfeeding poses potential harms. This third one was much more specific and referenced birth defects. I wish to have it be more general, the one used in the other 2 places, and remove this one. Consistency, and this one is more specific, and I prefer the more general one.
Second.
We have a due pass, Representative Roberts, second by Representative Echols. Any questions on amendment number 2 for the author? Seeing no questions, we will call amendment number 2 for a vote. All in favor, raise your hand. Any opposed? Abstain? We have 1 abstention. Declare amendment number 2 to have passed. Those are all of the amendments that we have before us, unless someone has come up with something in the past few minutes. With that, we will bring forward the working draft version 1.5 as distributed this morning and as amended by the 5 amendments that we have made today. Questions on I almost said questions on the bill, that would be inappropriate. Questions on the recommended rules? Representative Echols.
Mr. Chairman, we have in an extremely open process that I actually have been proud to be a part of over these last couple weeks, debated this, admitted things we didn't know, talked about really, really hard questions, and I think came up with a good work product. So at this time, I would move, unless there are questions, I would move that the committee accept this draft as a recommendation that the committee would make to the Board of Health for testing and labeling standards.
We have a motion from Representative Echols, a second from Senator Yack. Question from Representative Loring.
Thank you, Mr. Chairman, and I'm as concerned as everybody else about the testing standards and labeling and the need to get this done, but could we walk through the process? So let's say we approve this, which I anticipate is going to be what happens. We send it to the health department, they then approve it, and so it is then officially the rules. What is the enforcement mechanism to make sure, I mean, the way I'm recalling how this works, there has to be a statutory authorization for them to enforce rules. And I'm just questioning whether or not we're adequately dealing with that issue.
I have many puzzled faces. It is my understanding, and I'm not a lawyer answering a lawyer's questions about legal matters, which is probably never a good idea. It is my understanding that through this process, that there are things that State Question 788 allowed the health department to make rules on. Where we got into trouble is that it was the belief of the Attorney General that the first set of rules made by the Board of Health overstepped the authorizations that 788, which is statute. So we have existing statute that gives the health department powers to make these rules. They overstepped that according to the letter submitted by the Attorney General. In reaction to that, the Board of Health retracted a lot, I mean, almost all, I would say, of the rules that they had put in place. Kind of since that reaction to pull back so much, it was the testimony of the Department of Health that they probably did have the authority through State Question 788 and through the statute, that 788 became, to do what we're asking them to do today. And so that's where the authorization would come from, is from 788 itself. Follow up, yes.
Thank you. So, and I understand what you're saying. I guess my next question is, and if they don't approve what we are recommending, I mean, this is simply a recommendation from us. So if they don't, what's our next step?
I will answer, this is a personal answer, obviously.
And I think that's as good as you can give.
And so I will give my personal opinion will be, we're proceeding down this track because it is the fastest way to get testing and labeling standards onto this product. If the Board of Health rejects, I don't even want to say if they reject these recommendations, if the Board of Health refuses to do something about testing and labeling, whether it is what we send them or something different, better, whatever, I think at that moment, the need for the legislature to be called into special session goes through the roof. And so I believe that if the Board of Health rejects this, it would be my recommendation to this committee for us to ask the governor to call for a special session for testing and labeling. Senator Daniels.
Yeah.
Thank you, Mr. Chairman. So to clarify on your opinion, and I hope that doesn't have to happen, would you also agree that that call would be very specific to addressing testing and labeling, since this task force is trying to come up with something we can recommend to all of our colleagues, and these are the subject matters we have covered most thoroughly for now? So is that the parameters, are those the parameters you would put on such a request?
That would be my opinion. I am pretty sure if we get to that point that opinion will be hotly debated. But my opinion is, and by the time we get there, we may be ready for more. And we're going to talk about that after this vote, is that this is not the end of the work of this committee. The next step is a much bigger step, and that is to pick up the Unity bill and to put it into whatever form it is this committee deems appropriate and then recommend that to the legislature. If we have finished that work and we're going to be going into special session, then we should, then having a much broader call may be appropriate. In the end, that's a question for the governor, and the governor will craft that call. But yes, until, it's my opinion that until this committee has come to terms with the Unity Bill and all of the facets that surround somewhat of an omnibus medical marijuana bill, if we don't get testing through the rulemaking process, then I would think a narrow call that could happen as soon as possible would be warranted. Representative Loring.
Again, thank you. In a broad sense, I completely agree that we need to address these issues of testing and labeling immediately. But there are other issues that I likewise feel like need to be addressed immediately. I mean, for instance, we have 900 some grow licenses that are issued. I'm very concerned about the big picture ramifications of that. And the longer we wait to deal with those issues, I think the worse the situation is for us to try to deal with those. So, I mean, we do have the Unity Bill in front of us. While I don't think anybody thinks it's perfect, it's a good compromise. I didn't get the reassurance that I wanted to hear that we're going to proceed on with the Unity Bill, I guess is what I'm saying.
And so you're looking for more assurance from me that we're going to move forward with the Unity Bill? Is that your question?
Yes.
I will give you assurance that we as a committee are going to be given the opportunity to look at, discuss, amend as necessary, and vote to make a recommendation to the legislature that they pass whatever that final form is. I know that there are members of the committee who have sections, not the whole bill, but there are sections of the Unity Bill that give some members of the committee some heartburn, and I think that it is our job to work through those sections and make sure those are recommendations that we want to make to the legislature, to the Senate and the House as a whole. But that is definitely our intention, and I feel pretty safe speaking for my co-chair that is the next thing on this committee's agenda, for sure.
Thank you.
Other discussion, we have a motion and a second to approve these recommended rules as amended. Any other discussion or questions before we hold that vote? Seeing none. All in favor of working draft version 1.5 as presented to the committee today and as amended by the committee today, to make that recommendation along with the cover letter from my co-chair and I with some of the things that we have added. All in favor of that, raise your hand. All opposed? That is a unanimous vote. Thank you very much. That concludes our business today. I want to talk a little bit, going back to what we just discussed. First, I would like to emphasize how incredibly historic what just happened here is. And I will take the liberty of saying how proud I am of this committee and the work that we have done. And I'll even allow an outburst. None of us had a clue exactly what would happen next when we came in for the first meeting of this committee, for sure. We have had our ups, we have had our downs. The fact that the House, the Senate, the Democrats, and the Republicans came together today and in a bipartisan, bicameral, unanimous fashion drafted language, worked through 5 different amendments to get it right, so that it was not a process of just hurriedly shoving language down someone's throat, but to work together to do it right is something that I think that we should all be very proud of. Representative Echols and I, again, he can tell me when I speak for him and I shouldn't, but the task that we were given by the pro tem and the Speaker of the House when we started this 12 weeks ago was to go out and gather all of the information that we needed to gather to put forth good recommendations to the legislature. And that is what we will do next. Part of this process, really, I think without some of the pain of the last 12 weeks, the Unity Bill would not exist. And the next step would be significantly harder than I think it is going to be. And so we thank those people who were willing, not inside the legislature, but outside, willing to sit down, some of them friends and foes, and come up with the Unity Bill. And in many ways solve a lot of the problems that were ahead of us. We've found solutions through this process. So what we will do next, and this I very much want the members of the committee listening, and we will put this out in emails to you also. I know a few members were not able to attend today. We're not going to go through the painful process that we just went through. Trying to amend 8 pages or 10 pages worth of rules took 3 weeks and a whole lot of pain and a whole lot of awkwardness. So what we, my co-chair and I have discussed is we would like over the next few days for each of you to submit any issues, questions, research that might need to be done, whatever it may be, via email to us. So as I said, I know some of you have issues with a few sections of the Unity Bill already. I have a few issues with the Unity Bill myself. Instead of having to wait until next week, come into this room, have those things brought up in the meeting, me try to duck a million questions like I did 2 weeks ago in this room, trying to answer questions that I didn't know the answers to. We would like, instead of being here and basically wasting our time with a meeting next week, I think it'll be much more valuable for you to submit those things to us, and we will be submitting them to staff to try to answer those questions and try to have actual educated responses before we get back together and discuss those parts of the Unity Bill that we have issues with. So we will not meet next week. And really, when the next meeting we have, that date will be determined in large part on the volume of work that we're going to give staff. We will not come back here until we are ready to have educated discussions on those sections of the Unity Bill that are up for debate. Going through a 400, or I don't remember how many pages the Unity Bill is, a big old bill, page by page, line by line in this room would be almost impossible. And so we're going to ask by noon next Wednesday that you have those things submitted to us. And that gives you Wednesday morning, which is your normal marijuana time to work on it. since y'all are already giving me dirty looks for giving you a 1-week deadline. Man, some seriously dirty looks. We may extend that deadline. My co-chair and I will discuss the deadline after this meeting. But we would like those submitted. We will notify you when the next meeting is and kind of give you the background, the questions, and kind of the parameters of how we're going to move forward. A lot of that will depend a lot on your emails and the questions that you ask. So with that, we'll turn it over to my co-chair, and then we'll try to wrap all of this up. We'll go ahead and then Senator Paxton has a question, but Representative Echols first. Okay. Senator Paxton.
Mine's a very, very quick question. The version I'm working off of the Unity Bill is a 208-page version. Is that the proper one?
Let me double check.
Thank you very much. We will, and this is something that I had in my notes, but then I didn't look down when I started talking. We will make sure that we all have the latest version, because there have been many versions. So we will distribute the latest version of the Unity Bill to each of you by email, because yes, the last thing we want is for us to spend the next 2 weeks submitting edits to multiple versions of the same bill. So we will submit to you the bill that we want you working off of from here on out, and that will be whatever that latest version of the Unity Bill is. Thank you very much for the question. Senator Daniels.
Thank you, Mr. Chairman. I hope your version's the one that I have. My printer at home is beginning to, yes, wear out. Anyway, have Senate or House legal staff weighed in at all on anything about the Unity Bill before we go through and start to assess it ourselves? I've done part of it. Will you share with us any communication we have from legal staff about where there may be some red flags, if those red flags exist?
That's a good idea.
Or is it up to us to ask those questions individually?
Why don't we do this? Because I think you're right. I think before we delve into it, having some thoughts from them. So we'll ask legal staff, because it has not been run through legal review. I know from discussion that one of the issues or worries, or however you want to word that legal staff has, is that there are a lot of sections of existing statute that it seems that the Unity Bill is changing, but we are not changing the existing statute. So there is a concern, I believe, held by legal staff that if we actually go in and just pass the Unity Bill, we are going to be setting up a multitude of dueling statutes that have differing opinions on the exact same subject. So that's something we're going to need legal staff to kind of help us out with, for sure. Representative Echols.
I just want to say before we're done, I'm excited about this next step of the process. I'm excited. There's an awful lot of cleanup work that needs to be done with the Unity Bill, and as far as format, Senator, and I agree, maybe the next step is to have legal staff kind of delve into it. We'll work on that. What I wanted to say in the committee, because I had told my Democrat colleagues I was going to say this, I want to commend, I think, Representative Loring, Representative Rosecrans, Representative Leader Copeland, I want to say it publicly, on the House side, how diligently they worked, how hard we've worked together. I want to talk about Representative West, Representative Bush, Representative Roberts, Representative Fettgetter. They've put in a lot of time in this. And, you know, it's funny when you're in the legislature, a lot of us were in campaign season, so we're talking about why we run. You know, why do we do it? And I tell people I do it because about 75% of the days, I leave this building just as frustrated as can be and gripping my steering wheel as tight as I can, saying I'm never coming back and I hope I see none of you people ever again. But there are a few days. There are a few days you go home and you get to drive home and you get to say, the state of Oklahoma was better because I individually was up here today. And for all of us that have experienced that, that's why we do it. We do it for those days. It's like me, I'm a bad golfer, but there's that shot that brings me back. You know, we had a whole lot more press here the first day because that's historic. And those of us that have been here long enough know those days that we made the state better, normally we're the only ones that know. We're the only ones that go home saying things were better because we did it. Things were better today because of what we did. They were better because we put down partisan politics and we worked together. They were better because we put down bicameral politics, which can be just as nasty as partisan politics. And we had a room full of people that wanted to do what was right. We worked through some hard issues that not everyone agreed with on everything, and we compromised. And today is a day I'm going to go home feeling like it was better. And it won't get all the pomp and circumstance the first day got, but it was a good day. And I want to encourage the committee, let's keep up that same work as we enter into the next phase. And let's continue to have these strong disagreements about policy that we find a way to work through, because we still can set the example. I think Representative Loring was 100% correct. There's a lot of things left to be done. And we need to set the example in the state of Oklahoma as to how we implement the will of the people. And we do it in a way that the people can be proud of. And there were a lot of legislative days last year. I think with the process, none of us walked out proud. I'm walking out proud of the people I work with in this room and what they've done on both sides of the aisle in both chambers. You worked very hard on this, and I'm very excited to enter in this next phase with the co-chairman and having an imperfect baseline to start with in the unity bill that's going to need some tweaks and is going to need to put in ours, but we have something that we can work towards and we have something we can work with, and I can't think of a better group on all sides. We tease each other a lot, but at the end of the day, I'm proud to work with every one of you, and I want to make sure I said that publicly. And then, well, I listed my House members by name. I think the exact same thing of my Senate colleagues that have just been incredible to work with, and I wanted to publicly say thank you and how important it was to me.
With that, we will adjourn this meeting, and you will be notified when the next meeting will be held.